Hey guys, it's Jacob Blizzard again. I'm a board certified criminal law and criminal appeal specialist attorney. So whether you pled guilty or whether you went to trial, your lawyer has to be effective during the pretrial process. And that is the time before you went to have a jury trial. Not everybody who's had a pretrial or federal sentencing has had a trial because a lot of people plead guilty. So ultimately here we're talking about the right to have effective assistance of counsel in the pretrial process. And I want to give you some examples. A classic example is going to be the failure to convey a plea bargain that was offered by the federal government. So it's not often that plea bargains are made in federal criminal cases in the traditional sense of state cases, because state cases a prosecutor may say, okay, if he pleads guilty, he'll get 5 years or 10 years or whatever. In the federal system, you are not often going to get a plea bargain. It's going to be an open sentencing where you plead guilty and the judge just assesses your sentence according to the guidelines. However, there are instances where the government will make a plea bargain offer. Perhaps they will make an offer to drop a certain number of counts of the indictment if you plead to one, or they'll agree to plead to a lesser included offense, and they would do that by information. So they would just file a new document that you would plead to that new information instead of the indictment, that would lead to a lower sentence cap. So for example, maybe your case was a 5 to 40 drug conspiracy indictment, but they agreed to do a 0 to 20 to cap your sentence. And then your lawyer failed to give you the information about it, and so you went to trial and you were convicted and got 35 years. Obviously that is going to be ineffective assistance of counsel if your lawyer failed to inform you about this plea bargain that could have gotten you capped at 20 years. That's a really good classic example that we see happen all the time. Another classic example is going to be ineffectiveness in pretrial investigation. That's the lawyer failing to investigate the case, talk to witnesses, get an investigator, get experts as needed. And not every case requires the same type of investigation. So don't be thinking, oh, in every case, my lawyer, he should have gotten an investigator, he should have gotten an expert, he should have done all these things. That's not necessarily the case. But a lawyer is required to do a pretrial investigation where he looks into the facts of the case. So he's going to get the discovery from the United States, and he's ultimately going to check things out. You know, he's going to look and see, oh, they said there was an eyewitness to this aggravated assault, and so I'm going to go talk to this witness and see what they had to say about the whole thing. See if they really were there, or what they really did understand that happened. Or there's another witness listed in this police report that the police didn't even really talk to, but they're listed as a bystander. I'm going to get a private investigator to go find that person and go interview them. There's all kinds of things as an attorney you make professional judgment about, and sometimes that can't be questioned because the lawyer is entitled to make professional judgments that may ultimately lead to bad consequences because, you know, it turned out not that great. It's ineffective when the lawyer didn't follow through on some basic requirements to give due process to his client. And so, for example, the failure to investigate, the failure to talk to witnesses, seek out witnesses, also on the lines of failure to investigate, and this is not necessarily pre-trial in the sense of what it relates to, but it still occurs during the pretrial process most of the time, is to look for mitigating evidence. You're going to want to find evidence of mental illness, of insanity, of previous abuse that you've suffered, of a hard life growing up, of just difficult circumstances of a person. There's all kinds of things that mitigate a situation, you know, or perhaps a situation of the other person being an aggressor in a violent crime. You're looking for those mitigating factors that are going to persuade the judge potentially to go to the low end of the guidelines, or for the judge to depart downward from the guidelines and give a lesser sentence in light of those factors. So, important thing to consider when thinking about your case, pretrial ineffective assistance of counsel.